Hello and welcome to An Academy, a one-stop destination for the English medium civil services aspirants. A 5-judge Constitution bench of the Supreme Court had to decide if Section 6 capital A of the Citizenship Act is constitutional. The Citizenship Act of 1955 was amended in 1985. That's how Section 6 capital A got inserted into this law because of the Assam Accord of 1985. And today, the 5-judge Constitution bench of the Supreme Court, by the majority of 4:1, in this case, ruled in favor of the Section 6 capital A of the Citizenship Act of 1955, upheld Section 6 capital A of the Citizenship Act of 1955. In this session, let us look at all that you need to know regarding this topic. And towards the end, if you would realize that this session has been of help to you, you have understood this topic, do not forget to press the like button. That is what gives us encouragement to bring more such useful content for the betterment of the student community. And subscribe to our channel if you haven't yet. So let's get started and let's go back to the year 1826, the Treaty of Yandabu, when Assam was ceded by Burma to the British. And that's how Assam became part of the Bengal province. But the migration into Assam has been a political, social issue in Assam for a long time. Look at what is there on your screen. C.S. Mullen, 1931, in the census report, he says something has happened over the past few decades, and because of that, Assam, it is going to alter, maybe permanently, the indigenous culture of Assam and may destroy it completely. And this is because of the migration of people into Assam, particularly from East Bengal, because they migrated to Assam for land. A member of the Constituent Assembly, because Constituent Assembly was framed to draft the Constitution of Independent India, a representative from Assam asked the Constituent Assembly that there should be some special privileges, some constitutional protections, safeguards for the indigenous people of Assam. Why? Because we are facing problem with respect to migration, which affects our culture, which affects our language, which will alter the whole demography of Assam. But instead of providing special protection to Assam, the Constituent Assembly went ahead and enacted provisions related to citizenship under Part 2 of the Constitution. Now listen to me carefully. Normally, matters related to citizenship are not mentioned in the Constitution because this matter is left to the political class, to the legislature, that you decide who can become the citizen of this country. You can regulate all matters related to citizenship. But what is citizenship? In the words of Professor Hannah Arendt, citizenship is the right to have the rights. When you are given this right of citizenship, then you can claim other rights. Then you can claim all the political rights that are provided by the Constitution. That's when you can be eligible to vote in the elections. That is how you are eligible to contest elections. That's how you can occupy important constitutional positions. That's how you can apply for government jobs. Professor Hannah Arendt says citizenship is the right to have the rights. But the member, the representative from Assam, what he was asking for? Special safeguard protection for Assam in the Constitution. What was instead provided? Part 2 of the Constitution. But this Part 2 of the Constitution deals with citizenship at the commencement of the Constitution. This phrase, at the commencement of the Constitution, is very important because we will repeatedly revisit this phrase because that is very important for you to understand today's judgment. Why then was India unique in having citizenship matters mentioned in the Constitution itself? because the country was partitioned, unfortunately on the grounds of religion. So we had to be absolutely sure who are the citizens of India so that we can confer rights and benefits on the people of this country, the citizens of India. That is why Part 2 of the Constitution, which deals with citizenship matters, only talks about citizenship at the time of the commencement of the Constitution. Who can be the citizen at the time of the commencement of the Constitution? This is where Article 5 of the Indian Constitution, which laid down the jus soli principle of citizenship, which means law of the soil. Whoever is born on the soil of India is the citizen of India. Or if you were born to an Indian parent, or your grandparents were Indians, or great-grandparents were Indians, and you are residing in India for 5 years, you are ordinarily residing in India for 5 years, you are the citizen of India under Article 5 of the Constitution. So Article 5 talks about what? Citizenship at the time of the commencement of the Constitution. Whoever is born on the soil of India, or your parents, grandparents, great-grandparents have been the citizens of India, or you have been residing in India for 5 years, you are the citizen of India under Article 5 of the Constitution. But then something else happened. When the country was partitioned, it left numerous scars on the psyche of the people of this country, because it also led to one of the worst migrations of people. Millions of people migrated from India to what became Pakistan, and millions migrated from what became Pakistan back to India. Article 6 deals with those who migrated to India from Pakistan. So if you were born on the soil of India, you are a citizen. But what if you have migrated from Pakistan to India? What will be the status of your citizenship? And this is dealt by Article 6 of the Constitution. Not Section 6 of the Citizenship Act, but Article 6 of the Constitution. And Article 6 says, who can be the citizen at the time of the commencement of the Constitution? If you or your parents or your grandparents were born in India as per the Government of India Act 1935, and in case you had migrated to India from Pakistan before 19th July 1948. Now this 19th July 1948 is what? It is now a cut-off date for citizenship. What about the rights of citizenship of those people who migrated to India from Pakistan? If you have migrated from Pakistan to India before 19th July 1948, you are the citizen of India. But it may also be possible that people would migrate from Pakistan to India after this date, 19th July 1948. Which means if you have migrated to India before this date, you are the citizen. If you have migrated to India on this date or after this date, then you have to register. You have to register to become the citizen of this country. But there is also a caveat. You can register to become the citizen of India, but for that you should have stayed in India for 6 months before you can apply, before you can register to become the citizen of India. Why this is important, I'll tell you slightly later, but keep that in your mind. Which means the cutoff date would be 26th July 1949. So how can you say this? Listen to me carefully. Citizenship at the time of the commencement of the Constitution. What is the commencement date of the Constitution? 26th January 1950. But listen to me carefully. Although the Constitution was enacted on the 26th of January 1950, but the Constitution was adopted on 26th November 1949. Although the Constitution entered into force on 26th January 1950, but there were some sections of the Constitution some articles of the Constitution, some provisions of the Constitution, which were implemented at once. That means not at the time of the commencement of the Constitution, but at the time the Constitution was adopted. And when was the Constitution adopted? 26 November 1949. And citizenship matters were implemented at once on 26 November 1949. But even then, Article 6 says citizenship at the time of the commencement of the Constitution, which means if you have migrated from Pakistan to India before 19 July 1948, you are the citizen. If you're migrated after this date or on this date, after this date, then you have to register. And to register, you should have stayed in India for 6 months, which means there is a temporal limit. What is this temporal limit? That means it is not that if you migrate into India after 19 July 1948, forever and ever you can become eligible to become the citizens of India. All you have to do is register. No, there is a temporal limit. There is a time limit. And what is the time limit? 26 July 1949. Why? Because 26 July 1949 till 26 Jan 1950, that's the 6-month period. Which means if you have entered India on or after 19 July 1948, for that you have to register. And to register, you have to wait for 6 months. That means if you have entered India on 26 January 1950, you are not eligible for citizenship under Article 6, because you should have ordinarily stayed in India for 6 months, which means then backwards of 6 months till 26 July 1949. If you have entered India after 19th July 1948 till 26 July 1949, then you can register to become the citizen of India, which means Article 6 is not meant to be in operation forever. There is a temporal limit. It will be limited till 26 July 1949. And keep this in mind, temporal limit. What this temporal limit is, why it is important, I'll tell you when we will analyze this judgment which was delivered by a 5-judge bench of the Supreme Court today, in which one judge dissented, Justice Pardiwala. Why did he dissent? That's also something that we will discuss. This is Article 6. But you might wonder, why this different cutoff? According to experts, there were 2 waves of migration which happened. Prior to 19th July 1948, these were the people who were predominantly Hindus who migrated back from Pakistan to India. But then after 19 July 1948, there was another wave of migration where the Muslims who had migrated from India to Pakistan, now they wanted to come back because they realized the vision of Pakistan that they saw, the dream of Pakistan that they saw, did not live up to their expectations, and they wanted to come back. And if they have to come back, they want to come back, for that they have to register to become the citizens of India. And even there is a temporal limit, 26th July 1949. Then Article 7, it talks about rights of citizenship of certain migrants to Pakistan. In the previous article, we discussed what will be the citizenship of those who migrated from Pakistan to India. Now we are talking about what about those who migrated from India to Pakistan and now wants to come back. This is what we talk about, remigration or reverse migration. Constitution said under Article 7, whoever migrated from India to what became Pakistan after the first day of March 1947, you are not the citizen of India, which means you left this country. Then you migrated to a country which became Pakistan. You are not to be deemed as the citizen of India. Why this date, 1st March 1947? This was when horrific communal violence broke out in different parts of the country, particularly in Punjab. And on this date, there was a wave of migration where people migrated from India to Pakistan. And on this particular date, if you have migrated from India to Pakistan, you cannot become the citizen of India. But then what if you want to come back? Can you come back? Yes. But you can come back only under a permit for resettlement or what is known as permanent return. If you want to come back, you have to apply for permit, which means the government should allow you to enter India. With this intention that you want to return permanently, then you don't want to go back. Which basically means you want to restrict people from migrating from Pakistan now back to India. Only those who are allowed by the government of India, by this permit system, they can enter India. And they will be deemed to have entered India after July 1948, 19 July, which means even if you have come back, you have to stay in India for 6 months. Only then can you apply for the citizenship. Then you can become the citizen at the time of the commencement of the constitution. Which means here also there is a temporal limit. What is this temporal limit? Which means even Article 7 is not meant to be in operation forever and ever and ever. If you had migrated after 1st March 1947 and now you want to come back, you can come back only if we allow you to come back by giving this permit system. Clear? And that means you will be deemed that you have entered after 19 July 1948. Because those who have entered after 19th July 1948, they have to stay in India for 6 months. Only after that they can apply for citizenship. Which means even here the cutoff date becomes 26 July 1949. Now listen to me carefully. Article 6 talks about registering for citizenship. Registering. You have to register to become the citizen. Article 7 talks about permit system. Article 6 does not talk about permit system. Article 7 talks about permit system. That means if the government allows you by issuing a permit, only then can you enter India. But listen to me carefully. This reverse migration, that means people migrating from Pakistan back to India. Pakistan consists up of West Pakistan and East Pakistan. It is this East Pakistan which later on got liberated in 1971, and this East Pakistan became Bangladesh. Now listen to me carefully. Ordinance was issued. Then rules were made. Ordinance was issued, then rules were made. Why? To restrict the entry of people or to regulate entry of people from West Pakistan to India. That means we issued permit system only for those who were to migrate from West Pakistan to India, not East Pakistan. So an ordinance was promulgated, rules were made so that we can provide this permit system for those who are migrating from West Pakistan to India, not East Pakistan. For East Pakistan, rules were not made. Why? I'll tell you slightly later. Later on, another ordinance was passed saying we want to restrict or we want to provide permit system for those who migrate to India from any part of Pakistan. Sir, what are you saying? I'm saying there is a migration of people from Pakistan to India. In the initial wave of migration, which happened before 19th July 1948, where predominantly Hindus and Sikhs migrated from Pakistan to India, now they have been taken care of. After that, there was another wave of migration where predominantly Muslims from Pakistan wanted to come back because they did not accept, they were not happy with the kind of Pakistan which was created there. And now they wanted to come back. Now to regulate their entry back into India, ordinance was promulgated. without permit system, you cannot enter India. But this permit system was primarily meant to regulate the entry into India from West Pakistan, not East Pakistan. Specifically, ordinance said permit system for those who are migrating from West Pakistan to India, and for that rules were made. Later on, this ordinance, another ordinance was promulgated saying this permit system will now be applicable for those who are migrating from any part of Pakistan to India, which means any part means West Pakistan as well as East Pakistan. But even here, rules were not made for East Pakistan. Rules were not made for regulating the migration from East Pakistan to India. Rules were made only for West Pakistan. Now you want to ask why? And the answer to this question is given by a member of the Constituent Assembly, Gopala Swami Iyengar. He says, look at the geographical placement of East Pakistan. It is somewhere in the middle. Here is West Bengal, here is Assam and the Northeast region. There are Indians who, because of some avocation, who because of some work, they will go to East Pakistan. So if we regulate their entry, we might lose out on Indians as well. So because of the geographical placing of East Pakistan, which was between Assam, Northeast and West Bengal, there are Indians who travel to East Pakistan, then they come back because of some work, because of some occupation, because of some avocation. That is why we cannot regulate the migration from East Pakistan back to India. But Constitution was enacted 1950. Although the provisions related to citizenship were implemented on the 26th of November 1949. Then because of this ordinance, rules, primarily we were regulating through the permit system the migration of people from Pakistan, from West Pakistan to India, not East Pakistan. And this East Pakistan later on became Bangladesh. Article 10 of the Constitution is very important. It talks about continuance of the rights of citizenship. If under Article 5, under Article 6, under Article 7, you were deemed as the citizen of India, even after the commencement of the Constitution, your citizenship will continue, provided Parliament will regulate it, subject to the provisions made by Parliament by law. And why this is important? Just listen to me carefully after a moment. Even now, listen to me carefully, but I will tell you the answer to Article 10 significance for today's judgment slightly later. So what Article 10 says? Continuance of the rights of citizenship. If you were deemed citizen because of Article 5, because of Article 6, because of Article 7, you will continue to remain the citizen even after the commencement of the Constitution as well. Why? Because Part 2 of the Constitution, it deals with citizenship at the time of the commencement of the Constitution. And Article 11, it gives unfractured power to the Parliament that you can regulate all matters related to citizenship. Article 11 says, no matter what is mentioned in Article 5, 6, 7, 8, 9, 10, no matter what is mentioned under Part 2 of the Constitution, Parliament has the power to regulate any matter related to citizenship. And whatever we have discussed previously, that cannot derogate the power of the Parliament. Derogate means that cannot diminish, that cannot reduce the power of the Parliament to make any law for the acquisition of the citizenship, for the termination of the citizenship, any provision. Which means Article 11 has now overriding power over other articles of Part 2 of the Constitution. Because it is Article 11 which will override Article 5, 6, 7, 8, 9, 10. Why? Because these are the articles which are there meant to tell us, citizens of this country, at the time of the commencement of the Constitution. After that, Parliament will decide. And that's what I told you at the start. Normally, citizenship matters are not mentioned in the constitution of other countries. That is a matter which is left to the legislature. You decide. And that power was given to the parliament by Article 11 of the Constitution, and also saying specifically that no matter what is mentioned previously, that cannot derogate, that cannot diminish, that cannot reduce the power of the parliament to make any provision, to make any law for regulating any matter related to citizenship. And that's how in the year 1955, the Citizenship Act was passed, was enacted. And it is this Citizenship Act which tells us who can become the citizen of India. How can you lose the citizenship? So you can become the citizen of India by birth, by descent, by registration, by naturalization, by the acquisition of foreign territory. Or you can lose your citizenship by renunciation, by termination, by deprivation. All these matters are regulated by Parliament because Parliament has enacted this law using the power given to it by Article 11 of the Constitution. But before that, there was another law. Expulsion from Assam Act of 1950. Law specifically dealing with Assam. Why this becomes important? Because in this case, the petitioners argued, why are you singling out Assam? Why is there a different cutoff date for citizenship for Assam and for the rest of the country? Why are you only looking at Assam and not the other states in the northeast? And this will give you slight hint of some of the special features for Assam. Why? Because there are laws which are specific for Assam when it comes to migration, when it comes to citizenship. Expulsion from Assam Act of 1950. Why? This law was enacted to protect the indigenous, the original inhabitants of Assam. Whenever a law is to be enacted, for that there is a statement given. What is the object? What is the reason why we are bringing this bill? And what will happen if this bill becomes an act, becomes the law of the land? And the statement of objects and reasons for this law, Expulsion from Assam Act, was that we want to save, preserve the indigenous population of Assam. Why? Because this migration, this large migration into Assam, it has disturbed the economy of the province. It has also led to the disturbance in the law and order. And that is why we need a specific law to deal with the migration problem of Assam. And that is why we are empowering central government that you take steps and you expel illegal migrants who are entering, who have entered Assam. And this law was enacted in the year 1950. But even then, the illegal migration of people continued in Assam. Then the year was 1979. This is when the Assam agitation started. This agitation was led by all Assam Students Union and various other entities in Assam. Their principal objective was that this illegal migration into Assam, it has destroyed our economy, it has destroyed our culture, it has violated the indigenous rights of the indigenous people, and we need to put an end to this illegal migration. And for that, what we need to identify these illegal migrants. We need to arrest them and we need to deport them. This was the agitation, and this agitation continued till 1985. And finally, a political solution to this Assam agitation was found. And what is this political solution? In the form of Assam Accord. This Assam Accord was signed between the government of India, the government of Assam, and the representatives of this agitation led by all Assam Students Union and other entities. So a political solution to this Assam agitation was made in the form of Assam Accord. And this Assam Accord, the provisions of this Assam Accord says that we will identify who are these illegal migrants. We will arrest them, we will deport them so that this illegal migration into Assam will come to an end. How do you identify these illegal migrants? For that, you have to carry out NRC, National Register of Citizens. So if this was the political solution, what was the legal solution? The legal solution was amend the Citizenship Act and amend the Citizenship Act to provide for Section 6 capital A of the Citizenship Act. And remember, it is not Article 6A of the Constitution, it is Section 6 capital A of the Citizenship Act of 1955. So the political solution, Assam Accord was signed, Rajiv Gandhi was the Prime Minister, central government, state government and the representatives of the Assam agitation. And the legal solution was amend Citizenship Act, insert Section 6 capital A into this law, and this is the legal solution. And what this Section 6 capital A talks about? It talks about illegal immigrants of Indian origin. So what is this illegal immigration of Indian origin? India was one country, undivided India. Then it got split into India and Pakistan. Pakistan was made up of West Pakistan and East Pakistan. East Pakistan later became Bangladesh. So if we have to provide a mechanism by which we can regulate citizenship, for that we have to look at these illegal migrants of Indian origin, because after all they were part of the undivided India. And these illegal migrants into Assam were divided into three different categories. Those who came into Assam before 1966, those who entered Assam between 1st January 1966 and 24th March 1971, till 24th March 1971. And those who came into the state after, on or after 25th March 1971. So these illegal migrants into Assam, these illegal migrants of Indian origin into Assam, they were divided into three broad categories. Those who entered Assam before 1966, and what about them? They are to be regularized. That means they shall be deemed as the citizens of India. What about those who migrated into Assam between 1st January 1966 till 24th March 1971? Their names have to be struck off, expelled from the electoral rolls. That means for 10 years, they cannot contest elections. For 10 years, they cannot vote. Their names are to be struck off the electoral rolls, which means they are not the citizens, they are foreigners. But after 10 years, they can register to become the citizens of India and then stay in Assam. But all those who entered Assam on or after 25th March 1971, those are to be identified, arrested and deported. Why this date, 25th March 1971? Because this was the time, this was the day when Pakistani army launched Operation Searchlight. This is where they wanted to identify those, kill those, maim those, rape those who are supporting the liberation of East Pakistan. and wanted to establish their own new independent sovereign country called Bangladesh. So the official commencement of this war between India and Pakistan was on 25th March 1971 with the launch of the Operation Searchlight. And after that, there was massive migration of people into Assam, into different parts of the country. Why? Because these people wanted to save themselves from the agony of the war and they wanted to migrate. But since they are illegal migrants, they are to be identified, arrested and deported. And for that we need National Register of Citizens. This is what was mentioned in the Assam Accord. And to give legal cover to this Assam Accord, Citizenship Act of 1955 was amended. Section 6 capital A was inserted into this act in 1985 to give shape to implement the Assam Accord. When was this? 1985. But 2 years before 1985, in 1983, there was another law which was enacted. And listen to me carefully. Called Illegal Migrants Determination by Tribunals Act of 1983. This law was specific to Assam. One, expulsion from Assam, 1950, specific to Assam. Illegal Migrants Determination by Tribunals Act, 1983, specific to Assam. What? We have something called Foreigners Act. Foreigners Act was enacted in 1946. And this is the law of 1946 which deals with identifying illegal migrants, those who are not the citizens of India. So once those are identified, then their cases, because they are suspicious, we don't know whether they are citizens or not, but we suspect that they are not the citizens of India, we will take their matter to the tribunals, Foreigners Tribunal. And this tribunal will decide whether you are the citizen of India or not. If you are not, then you are to be arrested and deported. So for the rest of the country, regulating the illegal migration is dealt by the Foreigners Act of 1946. But for Assam, there was another law enacted in 1983 called Illegal Migrants Determination by Tribunals Act of 1983, which was specific to Assam. So those who are suspicious that you may not be the citizen of India, not the resident of Assam, we will take your matter to the tribunal and the tribunal will determine whether you are the illegal migrant or you are the citizen. Sir, why these two different laws? Listen to me carefully. It's not that this law was specific to Assam, but sir, you said this was specific to Assam. I'm saying that if Parliament wanted, if the central government wanted, it could have extended this law, Illegal Migrants Determination by Tribunals Act of 1983, to the entire country. But it did not. It extended this law specific to Assam. But for the rest of the country, we have the Foreigners Act of 1946. Then what is the difference between the two? Burden of proof. If I am declared suspicious, my nationality is suspicious, and my case has been referred to a tribunal under the Foreigners Act of 1946, the burden of proof is on me. I have to prove that I am the citizen of India, not the state. I have to prove that I am the citizen of India. Burden of proof is with the alleged illegal migrant. Sir, what is the burden of proof in this law? Not mentioned. When it is not mentioned, then we can safely assume that the burden of proof is on the state. So the state has to convince the tribunal. State has to prove before the tribunal that this particular suspicious individual is not the citizen of India. And you know, if the burden of proof is on you, it becomes difficult for you. If the burden of proof is on the state, it becomes difficult for the state to prove beyond any reasonable doubt that you are not the citizen of India. And under this act, some rules were also made. Illegal Migrants Determination by the Tribunals Act 1983, and then the rules were made. Sarbananda Sonowal, who later on became the Chief Minister of the state of Assam, filed a petition before the court challenging the constitutional validity of this Illegal Migrants Act and the rules. Why? He challenged, and a 3-judge bench of the Supreme Court said, this act and these rules both are unconstitutional. Why? Because you have tweaked the burden of proof. Under the Foreigners Act, the burden of proof is on the alleged illegal migrant. Under this Illegal Migrants Act, the burden of proof is not specifically mentioned, which means the burden of proof is on the state. The 3-judge bench of the Supreme Court looked at the report given by the governor of Assam in 1998 and said, in this report it was mentioned that there was a flood of Bangladeshi migrants into Assam. And this law and these rules have failed to check this illegal migration, which means this law and these rules are arbitrary because the burden of proof has been shifted from the alleged illegal migrant to the state. As such, it is unconstitutional. And it was in this judgment that the 3-judge bench of the Supreme Court in Sarbananda Sonowal said, when you are making a law, but that law is inefficient in dealing with illegal migration. Do you know what is the impact of that law? It violates Article 355 of the Constitution. What is Article 355? Article 355 imposes a duty on the union, on the central government. That central government, you have a duty. You have to protect every state in India from internal disturbance, from external aggression. There is another duty on the union, that you have to ensure that governance in every state is carried out according to the provisions of the Constitution. Since it is the duty of the center to protect every state from external aggression, but if you are unable to prevent Assam from external aggression, because illegal migration can be viewed as external aggression, which means through this law, through these rules, you have violated Article 355 of the Constitution. As such, this law, these rules are unconstitutional. Then in 2012 as well, and it was in this judgment that the court asked for the NRC, that you have failed to effectively implement the Assam Accord of 1985. And that is how, under the auspices of the Supreme Court, one judge was Justice Rohinton Fali Nariman, the other judge was Justice Ranjan Gogoi. They decided that under the court-monitored way, there should be NRC in Assam. And that is how NRC was carried out only for Assam, under the supervision of the Supreme Court. But in 2012, Assam Sanmilita Mahasangh versus Union of India, it was in this case that the petitioner challenged the validity of Section 6 capital A of the Citizenship Act of 1955. Justice Rohinton Nariman was the judge here, and he posed 13 judges and he posed 13 questions. And he said, since these questions raise larger constitutional questions, and to answer all these constitutional questions, we need to set up a constitution bench. And you would know under Article 145 Clause 3, a constitution bench cannot have judges less than 5. And that is how a 5-judge bench of the Supreme Court was constituted to decide upon the constitutional validity of Section 6 capital A of the Citizenship Act. Let's look at what were the larger issues that the court had to grapple with in deciding whether this section is constitutional or unconstitutional. Questions. Number 1. Whether Parliament was competent to enact this law, in a sense to amend the Citizenship Act and insert Section 6 capital A into the Citizenship Act of 1955. Was the Parliament competent to legislate? That's question number 1. Question number 2. Is Section 6 capital A violating Article 14? Why? Because Article 14 also talks about fundamental right against arbitrariness. And what is right against arbitrariness? Simple example. If I say that all those who join this class at 8 o'clock in the evening, they cannot ask me any questions. And those who join my class at 8:45, they can answer me 10 questions. They can ask me 10 questions. The way I am making these rules sounds as if there is no thought given to it before making these rules. These are manifestly arbitrary, without any logic. On the contrary, if I would have said that those who are poor engineers, they can ask me 10 questions, but those who have legal background, they can ask me only 1. I am classifying students, but not on the arbitrary grounds of when have you joined my class, at what time have you joined my class, but I'm classifying people reasonably. Because those who are poor engineers, they know nothing about the law, you can ask me 10 questions. Those who have the background in law, maybe you just need clarification and you can only ask me 1 question. So I am classifying people, but on reasonable grounds. It is not arbitrary. Petitioners argued that by just singling out Assam, by picking up this random date of 25th March 1971, it is manifestly arbitrary and as such violates Article 14 of the Constitution. Question number 3. Can Section 6 capital A be regarded violative of Article 355? Because that's what Sarbananda Sonowal judgment spoke of. That illegal migrants, determination by tribunals Act 1983 and those rules are unconstitutional because they violate Article 355. Question number 4. Whether 6 capital A of this Act violates Article 29 Clause 1 of the Constitution, which talks about the cultural rights of the minorities. Article 29 Clause 1 said, any section of the society, any section of the citizens residing anywhere within the territory of India, if you have a distinct language, script and culture of your own and you want to preserve that culture, you have the fundamental right under Article 29 to preserve that culture. This illegal migration dents the unique indigenous culture of the Assamese people. As such, this Section 6 capital A should be declared unconstitutional. Who said this? The petitioners. Various other questions. One more question was, is Section 6 capital A Clause 3 of the Citizenship Act unconstitutional on the grounds of temporal unreasonableness? And what is this temporal unreasonableness? We will discuss in a moment. And let's try and answer all these 5 questions one by one. And as I told you, this judgment was given by the majority of 4:1, 4 judges, led by Justice Chandrachud, the Chief Justice of India, and 3 other judges, ruled in favor of Section 6 capital A, saying it is not unconstitutional. Justice Pardiwala declared that this section is unconstitutional. On what grounds? We will discuss. But 4 judges said it is not unconstitutional. Why? Let's answer all these questions one by one. First is legislative competence of Parliament to enact Section 6 capital A. Now there can be a question on your mind, why was this question even asked? Why was this matter even raised? Because if Parliament cannot make a law, then who can make a law? Who has the competence to enact this law? Now listen to me carefully. Section 6 capital A talks about what? Different cutoff date for citizenship. Right or wrong? Right, sir. But if you look at Constitution under Article 6 and 7, it also talks about cut-off date for citizenship. That too from those who are part of India, undivided India. And for that the cut-off date is 19th July 1948. For Assam, the cut-off date is 25th March 1971 till 24th March. Those who migrated into Assam before 1966 January, they are the citizens. Those who migrated between 1st Jan 1966 till 24th March 1971, they will lose political rights for 10 years. After that, they can register for the citizenship. And those who migrated to Assam after 25th March 1971, you are not the citizens of India. So why this different cut-off date? If this section 6 capital A is part of the Citizenship Act, right or wrong? Yes. This act is an ordinary law. Yes, sir. An ordinary law can be enacted by simple majority. But by passing this law, by prescribing different date, cut-off date for citizenship, you seem to be amending Article 6 and 7 of the Constitution, which you can't do by an ordinary law, which if you had to do, for that you had to amend the Constitution, use Article 368 to amend Article 6 and 7. Which means the legislature, the parliament did not have the competence to pass this law. As such, it should be declared unconstitutional. But 4 judges did not agree. In fact, on this, Justice Pardiwala also did not agree. He ruled that Section 6A is unconstitutional because of another reason, because on another ground, not on this ground. Article 6 and 7, listen to me carefully, talks about citizenship at the time of the commencement of the Constitution. This different cut-off date, those who have entered between 66 to 1971, they will lose their citizenship, or they are not the citizens, they will lose political rights as well. Their names will be struck off the electoral rolls for 10 years. After that, they will become the citizens. After that, they can register for the citizens. And they will become citizens only after the expiry of that 10-year period. That means for them, you are not giving retrospective effect. If by this section 6 capital A, you would have said that those who have migrated into Assam before 1966 or before 24th March 1971, they shall be deemed as the citizen of India from the time of the commencement of the Constitution, that would have meant that you are amending Article 6 and 7. That would have required Article 368. But since it is not about citizenship at the time of the commencement of the Constitution, as such, you are not amending Article 6 and 7. As such, you don't need Article 368. As such, you can do this by an ordinary law. Another reason. We are talking about Section 6 capital A of the Citizenship Act. Right or wrong? Right. We are talking about migrants into India from Pakistan. But which Pakistan? West Pakistan. So Article 6 and 7 talks about migration into India from West Pakistan, but East Pakistan was not touched. Because for that rules were not made, as I told you at the start. And now this section 6 capital A talks about such people from East Pakistan, which is now Bangladesh, and to give them citizenship. So what was not covered by Article 6 and 7 is now covered by Article 6 capital A. That is why Parliament has the legislative competence to pass this law. Justice Chandrachud said, even if let's assume that by inserting this section, you are amending Article 6 and 7. But you are amending this through what? Through Article 11. Because Article 11 gives you the power to regulate all matters related to citizenship. And Article 11 also says what? Nothing in the previous provisions, notwithstanding whatever is mentioned in the previous provisions, Article 5, 6, 7, 8, 9, 10, that does not derogate the power of the Parliament to enact a law on citizenship. And derogate means that no power under Part 2 of the Constitution can diminish, can reduce the power of the Parliament to enact a law under Article 11. And Article 11 has been used by Parliament to enact Citizenship Act. And then this law was amended in 1985. So this is within the legislative competence of the Parliament. Not just this. Look at Schedule 7 of the Constitution, which talks about distribution of the legislative subjects into union list, state list, concurrent list. In union list at entry 17 is citizenship matter. When explicitly Schedule 7 of the Constitution, under list 1, which is union list, under entry 17 of union list, specifically talks about matters related to citizenship, acquisition of citizenship. Parliament is using its power to make law on union list to amend this article, to amend this section, to amend this law of 1955. And hence we can say that legislature is competent enough to pass this law. Petitioners had raised an important question, an important observation. Listen to me carefully. Slightly technical, but worth the time. Article 3 talks about reorganization of the states. Parliament may by law create a state by merging two or more states, split a state, change the name of a state, increase the area of a state, decrease the area of a state, alter the boundaries of the state. For that, what is required? An ordinary law. That is what these states reorganization acts are passed by simple majority, because these are ordinary laws. But even if they are passed by simple majority, they still amend the constitution. How? Schedule 1 and Schedule 4. Because when Telangana was carved out from Andhra Pradesh in 2014, Schedule 1 was amended. Now Schedule 1 says Telangana, because Telangana name got added. You are amending Schedule 1, basically amending the constitution. Schedule 4 was changed, which talks about representation of states in Rajya Sabha, in the Council of States. If there were 18 seats in Rajya Sabha given to Andhra Pradesh, now because of the Andhra Pradesh Reorganization Act, 11 seats were given to Andhra, 7 seats were given to Telangana. You had to change Schedule 4 to make these changes. Instead of 18 to Andhra, now there are 11 for Andhra and there are 7 for Telangana. So you are amending Schedule 1, you are amending Schedule 4. But how can you do that? Because you are amending the constitution. How can you do that? By not using Article 368. How can you do that? By passing an ordinary law by simple majority. Because there is an exception. What is the exception? Article 4. Whenever Parliament enacts a law under Article 2 or 3, there will be changes to Schedule 1 and Schedule 4. But those changes are incidental, coincidental, supplementary, and shall not be deemed as amendment to the Constitution within the meaning of Article 368, which means for that you don't need to amend the Constitution. You don't need Article 368 because Constitution under Article 4 itself says that although you are changing Schedule 1 and 4, but these changes are not deemed as amendment. Petitioner said, if, my lord, you want to change Article 6 and 7 by indirectly changing the cutoff date from 19th July 1948 to 25th March 1971. If Parliament had the power to do this, then just like Article 4, there should have been a proviso in Article 11 itself, saying when Parliament will use Article 11, it can make changes, and these changes shall not be deemed as amendment to the Constitution. Since there is no such clause in Article 11, which means even by using Article 11, even by using the power under Article 11, you cannot change, you cannot seem to alter, you cannot seem to amend Article 6 and 7. That is why it is unconstitutional. But Justice Chandrachud disagreed with the petitioner, saying there is a temporal limitation on Article 6 and 7. Temporal limitation is maximum it deals with giving citizenship to those who have entered India till 26 July 1949. After that, there is no point. That is why Constituent Assembly, the makers of the Constitution, did not deem it fit to make such a proviso for Article 11, because it is incomprehensible. How can you change Article 6 and 7? Because that is not required now. It has lost its scope. It only dealt with citizenship at the time of the commencement of the Constitution. So it is impossible to amend 6 and 7. That is why such a provision was not given. But long story short, does Parliament have the legislative competence to amend Indian Citizenship Act of 1955 by inserting Section 6 capital A? 4 judges said yes. In fact, all judges on this point said yes. Why? Because Parliament is using its power under Article 11. And Article 11 says that when Parliament will use this power, nothing that is mentioned in Part 12 can diminish, can reduce the power of the Parliament in regulating all matters related to citizenship. And in fact, Parliament is using its power under entry 17 of Union List 1. And you are not amending Article 6 and 7 by changing the cutoff date. No. Because this Article 6 and 7 was for those who migrated to India from West Pakistan. This different cutoff date is for those who are from Indian origin but migrated from East Pakistan, which became Bangladesh. What was not covered by the constitutional provisions 6 and 7 is now covered by this statutory provision, which is Section 6 capital A of the Citizenship Act of 1955. So question number 1 answered. Question number 2. Section 6 capital A should be declared violative of Article 14 of the Constitution. Why? Because the petitioners raised 3 important points. Point number 1. Section 6A is under-inclusive. Why? Because it confers citizenship only to the migrants to Assam. Why are you singling out Assam? What about other states in the neighborhood? Hence, it is arbitrary. Second, why single out only Assam? There are other border states as well. And you can treat all these border states as a homogeneous class. Likes should be treated alike. If Assam is to be treated in this way, then all the neighboring states should also be treated the same way, because they also share borders with Bangladesh. And you are providing a different cutoff date for those who enter Assam, while for the rest of the country it is 19th July 1948. But for Assam, it is 24th March 1971. This is manifestly arbitrary. And for that, you need to understand that whether it comes to Anwar Ali Sarkar case or various other cases. In fact, Joseph Shine judgment of the court, which decriminalized adultery. Various judgments of the court, they have said that under Article 14, you can classify people. Classification is possible. But this classification should be on reasonable grounds. This is what we call intelligible differentia. With reasonable nexus. Sir, what are you saying? Can Parliament, by enacting a law, classify groups? Yes. But this classification should be done in a reasonable manner. There has to be logic. It can't be arbitrary. If it is arbitrary, it is violative of Article 14. You have to tell us what is the purpose of this law. And then the purpose of this law should lead to classifying people. So what you are trying to achieve by this law, if for that you necessarily need to classify groups, you can do that. But there has to be nexus between what you want to achieve and why you want to classify groups or people. Petitioners argued that you could not have singled out Assam. All the judges said, no, this is constitutional. Singling out Assam from the rest is constitutional. In fact, Justice Pardiwala also said that the way Section 6 capital A was enacted, at that time it was constitutional. So all the judges said, this is not unreasonable. Why it is not unreasonable? Because Assam is different. And that is why I told you, expulsion from Assam Act 1950. Illegal Migration Determination by Tribunals Act 1983, specific to Assam. Which means we have realized Assam is different than the other states. As such, singling out Assam is constitutional. It is not unreasonable. Why it is not unreasonable? Because if you look at Assam, it shares 263 kilometers worth of border with Bangladesh. If you look at Mizoram, if you look at Meghalaya, in fact, if you look at Tripura, or for that matter West Bengal, all these states, they share borders with Bangladesh, which is much larger than the 263 kilometers border that Assam shares with Bangladesh. In fact, West Bengal, it shares close to 2,216 kilometers. Yet, if we look at illegal migration, the number of illegal migrants in Assam is 40 lakhs. The number of illegal migration into Meghalaya is 30,000, roughly. The number of illegal migration into West Bengal, for example, is 57 lakhs. Into Tripura, it is close to 3.25 lakhs. So despite the fact that Assam shares less border with Bangladesh as compared to other neighboring states, but when we look at the illegal migration, barring West Bengal, where there is 57 lakh illegal migration, in Assam it is 40 lakh, in other states 30,000, 3.25 lakh, which means Assam is different and we have to treat it differently. Now, sir, West Bengal is 57, so we should treat West Bengal differently as well. But look at the amount of land and the population. The population of Assam is less than Bengal. The land of Assam is less than Bengal. So if you look at Assam with less land, with lesser population and massive illegal migration, which means through this it can impose threat to the culture of the indigenous population. That is why illegal migration has to be tackled. And for that, if a new section is added for that, then we have to take into account. It is not unreasonable to single out, to exclude Assam from the rest of the bordering states of Northeast. And the intent of this law is to provide citizenship to those who are of Indian origin, who have already entered Assam, but then talk about also those who have entered Assam after 25th March 1971. Why? Because we are now classifying. If you have entered, look at the beauty of this argument. Before 25th March 1971 and after 25th March, on or after 25th March 1971. These people are the victims of partition. Those who have migrated prior to 25th March 1971, those are the victims of partition. Those who migrate on or after this date, when the war officially started, when Operation Searchlight started, these are the victims of war. And that is why this cutoff date, 25th March 1971, is not unreasonable, is not arbitrary, because we are clear-cut differentiating between two sets of migrations. One, those who are the victims of partition, those who are the victims of war. This law deals with victims of partition, not the victims of war, because Bangladesh was part of East Pakistan. East Pakistan was part of undivided India. That is why singling out Assam is not unconstitutional. Why Assam is different? I told you that the other states are covered under Foreigners Act of 1946. While as this law, Illegal Migrants Determination by Tribunals Act of 1983, is specific to Assam. For example, West Bengal. West Bengal between 1988 to 1993, or from 1983 to 1998, because of Foreigners Act of 1946, because this is the law which is dealing with identifying and then deporting the illegal migrants. More than 4 lakh illegal migrants have been deported. More than 4 lakh. And under Illegal Migrants Determination by Tribunals Act, only 10,000 have been identified as illegal migrants. Why? Because of the burden of proof. And here the burden of proof is on individual illegal migrant. Here the burden of proof is on the state. So two states, Bengal and Assam, which are facing problems of migration, they have to be dealt separately. Why? Because in Assam, because of this law, we could not tackle illegal migration effectively. And the government of Assam has given the report that more than 40 lakh in Assam are illegal migrants. So this question, whether Section 6A is violative of Article 14 of the Constitution, the answer given by all the 5 judges is no, it is not violative. Why? It would have been violative if there was no ground of keeping Assam separate from the rest of the states in the Northeast. If it was arbitrary, the way 25th March 1971 as a date was fixed as the cutoff date for citizenship, but it is not manifestly arbitrary, it is not an unreasonable classification. As such, it does not violate Anwar Ali Sarkar judgment, it does not violate the Joseph Shine judgment, it does not violate the Navtej Johar judgment, it does not violate any other judgment, it is constitutional. Third, the challenge under Article 355. The petitioners argued that Article 355 imposes a duty, as I told you, on the union, that you have to protect every state from external aggression and internal disturbance, and at the same time ensure that the governance in the state is carried out according to the provisions of the Constitution. Since external aggression can be viewed in the form of illegal migration into that state, and union is unable to ensure that there is no illegal migration, which means you are failing in your duty to protect the state from external aggression. Justice Chandrachud and other judges, they said we cannot judge a law or use judicial review on the grounds that this law violates Article 355. If we are going to do that, it will lead to unimaginable, catastrophic circumstances. Why? Because the court said, on what grounds can a law be challenged? How can you challenge a law? Number one, on legislative competence. Is the legislature competent in passing this law, in enacting this law? For example, if this law would have been passed by the Assam legislature, Assam legislature does not have the competence to pass this law. Why? Because this is a matter which is under union list. This is the power given to the parliament, not the state legislature. So if state legislature is enacting such a law, it can be challenged on the grounds that Assam legislature did not have the competence to pass this law. On this ground, you can challenge a law. What is the other ground? Violation of Part 3, fundamental rights. That's what Article 13 says. The state shall not enact any law which takes away or abridges the rights provided under Part 3 of the Constitution. And if the state does that, that law shall be declared null and void. Who says this? Constitution, under Article 13, Clause 2. So there are two grounds on the basis of which you can challenge a law. If the legislature did not have the competence in passing this law, or if this law is violative of the fundamental rights enshrined and guaranteed under Part 3 of the Constitution. Can this law be challenged on the proviso, on the provision of violating Article 355? No. But sir, 3 judges in Sarbananda Sonowal said yes. But in case of judicial discipline, the judgment of the 5 judges will have precedence over the judgment of the 3 judges. And in fact, the court said in Sarbananda Sonowal, the matter was different. Here the matter is different. So you cannot challenge a law. You cannot have judicial review for a law on the grounds that it seems to be allegedly violating Article 355. Because you can challenge a law only if the legislature is not competent in passing this law, or if the allegation is that this law is violative of the fundamental rights enshrined under Part 3 of the Constitution. Another matter. Does Section 6A violate Article 29, Clause 1 of the Constitution? Because Article 29, Clause 1 says, every section of the citizens residing anywhere within the territory of India, you have the fundamental right to preserve your culture. If you have a distinct language, script and culture of your own, you want to preserve that culture, that's your fundamental right. But Supreme Court said this Section 6A does not violate Article 29, Clause 1. Why? Because the petitioners have failed to prove it. You should have given us the data. You should have proved before us that it is because of Section 6 capital A that locals, indigenous population, original inhabitants of Assam, they are unable to protect and conserve their culture. In fact, Justice Surya Kant says, live and let live. This Section 6A is the manifestation of fraternity. And fraternity is one of the objectives mentioned in the preamble of the Constitution. You are given a fundamental right under Article 29 to conserve your culture. Tell us through your data, convince us that it is because of this section you are unable to conserve and protect and preserve your Assamese culture. And at the same time, preservation of culture does not mean cultural exclusivity. That we will have our own exclusive culture. There should be no diversity. If there is no diversity, how can we implement the preambular objective of fraternity? One of the judges said, you can't choose your neighbor. That does not mean under the garb of Article 29, you will say, we will choose our neighbor as well, so that there is cultural homogeneity. Then what will happen to unity and diversity? So Section 6 capital A does not violate Article 29 Clause 1 of the Constitution, because live and let live. Preservation of culture, conserving your culture does not mean cultural exclusivity. You can't choose your neighbor. This Section 6A is the testament, the manifestation of fraternity, which is one of the objectives of the Constitution. In fact, petitioners had raised another question. My Lord, International Covenant on Civil and Political Rights, Article 27 of this International Covenant, it talks about that states should not restrict or interfere in somebody's culture, in people's culture. The court said, number one, it does not impose any restrictions on the indigenous Assamese to preserve, conserve, protect their culture. Let's hypothetically assume that it does. Can an international law Trump, not Donald Trump, override a domestic legislation? No. So, Section 6 capital A does not restrict the indigenous Assamese people to protect their own culture, preserve their own culture, to conserve their own culture. But even if it does, can an international law trump override a domestic legislation? No. These were the arguments on the basis of which the 4 judges of the Supreme Court said Section 6 capital A is not unconstitutional, upheld the validity of Section 6 capital A. But Justice Pardiwala disagreed. Justice Pardiwala disagreed on what grounds? He did not say that just for Assam you could not have brought this section, because you have convinced me that Assam is different from the rest. So it is a reasonable classification. But it was reasonable at the time when this law was enacted. But over a period of time, it is manifestly arbitrary. There is manifest arbitrariness in the way this section has been implemented. Why? Because there is no temporal restriction. What temporal restriction? Listen to me carefully. If you have entered India from Pakistan after 19th July 1948, for that what you have to do, you have to register for citizenship under Section 6A, under Article 6. But if you had migrated from India to Pakistan after 1st March 1947 and then you want to come back, you have to come back through a permit system. Which in any case means you have to accept that you are a foreigner. Then you can enter into India on a permit system or you can register for the citizenship. That means you have to volunteer as a foreigner. You have to register as a foreigner. And then there is a temporal limit till 26 July 1949. If you come after that, which means you will not be eligible for citizenship, because you should have ordinarily resided in India for 6 months before the commencement of the constitution. So there is a temporal limit. But there is no such limit in section 6 capital A. There should have been a temporal limit. But Justice Pardiwala was told there is a temporal limit. There are 3 sets of people. Those who migrated before 1966, those who migrated from 1st January 1966 till 24th March 1971, and then those who migrated on or after 25th March 1971. There is a temporal restriction. It is not open-ended. Justice Pardiwala said, that's what I'm saying. At the time this law was enacted, it was not unconstitutional. Over a period of time, it has become manifestly arbitrary. Why? What about those, very interesting point, who migrated between 1st Jan 1966 till 24th March 1971? What will happen to those? Their names are to be struck off the electoral rolls. But who will strike their names off? Centre? But there is no mechanism in section 6 capital A. How do you do it? What is the procedure that you have to follow? There is no mechanism, no time frame provided by the law. If there is no time frame provided by the law, it violates Article 14 because it is arbitrary. Number one. Number two, Justice Pardiwala says all those who migrated during this period, they should have first volunteered that we are foreigners. Volunteered. That means they should have volunteered that strike off our names, because we have entered between 1st Jan till 24th March, strike off our names from the electoral rolls. We will remain in Assam. After 10 years, we will register for the citizenship. That means they should have volunteered that we are foreigners. Please strike off our names. But there is no voluntary thing in this section. This section says when you are identified as a foreigner, then we will have to see when did you enter. It means that I have entered Assam during this period, so I will continue to take the benefits of citizenship. My name will not be struck off of the electoral rolls. It is only when the state will identify me, then I will say, okay, since I entered into Assam during this period, and now you strike off my name from the electoral rolls. But maybe by that time 10 years are over. We are talking about after 1976, which means I was never deprived. My name was never taken off of the electoral rolls. That means it is the problem with the implementation of this law, that over a period of time it has become manifestly arbitrary, because there is no way for the centre to implement it. There is no mechanism for centre to implement this. And it is not that these illegal migrants have to volunteer and say we are foreigners. It is only when the state has identified you. That's when you are suspicious. That's when you will have to prove when did you enter Assam. Which means for a long time you will go undetected, unchecked. So this is manifestly arbitrary. There should have been a provision that all those who entered Assam during this period, they had to volunteer to get their names off the electoral roll. State should not have done that. They should have volunteered, and then they could have applied for citizenship. It was on this ground that Justice Pardiwala said this section 6 capital A is manifestly arbitrary. This was what we had to discuss. I think it took a lot of time. I thought we will cover it in an hour, but better understand a topic holistically than not understand at all. And if you have understood whatever we discussed today, do not forget to press the like button. Let me know in the comment section what are your thoughts. And if you have doubts, you can ask me your doubts and I will reply to your questions. And should you wish to get access to the PDF of this lecture, that shall be available on my Telegram channel. The link to join my channel is provided in the chat section. Any questions? Or shall we end the session? Okay then, thank you for staying with me. All the best. Bye-bye. Good night.